Good afternoon. This is Dr. Havens. This is the recorded lecture for the third and final chapter for week 1 of the leadership course, fall 2020. This is chapter 3, Nursing Practice in the Law. We have several objectives for this chapter. We're going to talk about different forms of law, talk about negligence and malpractice. We'll talk about the Nurse Practice Act and how it protects the public. And we'll identify a lot of issues around HIPAA, as well as the use of technology and the use of electronic medical records. Registered nurses are client advocates, and it's our responsibility to deliver safe and effective care to clients. This means that we adhere to established standards of care. Usually this relates to evidence-based practice. So we do what has been researched and is proven to be safe and effective. And this helps keep us safe legally. So let's talk briefly about what is the meaning of the word law. When we say it's the law, what does this mean? A law is a regulation. Laws are regulations that set forth social contracts, and they prescribe social conduct in a formal and legally binding manner. This means that if we don't adhere to them, that there will be consequences. There are 3 types of laws: statutory laws, which have been voted on by either a state legislative body or either Congress. Examples of these are the Affordable Care Act, the Patient Self-Determination Act of 1990, and also the Good Samaritan Law or Good Samaritan Act that sometimes affects nursing, that we'll talk about in just a few minutes. The second kind of law is called common law or case law. This means that if a certain decision has been reached in a case by a court, under common law, the next time that same type of complaint or suit is brought before a court, the court is most likely going to decide in accordance with the decision in the first case. Thirdly, there's administrative law. These are usually laws or regulations or ordinances passed by maybe state or local governments. These usually have to do with applications, licenses, and permits, and so on and so forth. The other type of law is criminal law. What we just described on the previous slide is different types of civil law. Criminal law, as you know, has to do with a crime against someone else or either against the state. Divided into 3 categories. Felonies are the most serious. This could be grand larceny, homicide, murder, that kind of thing. And then there are the misdemeanors. These are the lesser offenses like shoplifting, maybe for a small amount, traffic violations, so on and so forth. If you know, when I think misdemeanor, I think usually like trespassing, disturbing the peace, and that kind of thing. And then the third type of criminal law would be juvenile, which is committed by any offender who's under 18 years of age. Sometimes nurses are prosecuted in criminal court. This can have to do with falsification of medical records or either illegal use of controlled substances or actions of that nature. Civil laws involve people's rights usually. This has to do usually with contract law, labor laws, employment discrimination, and these things called torts. 4 specific types of civil laws that we want to take a look at here real quickly are torts, quasi-intentional torts, negligence, and malpractice. We've all heard of the last 2, and we're going to discuss them in a little bit of detail. So a tort law has to do with civil lawsuits, and basically the function is to compensate the victim or the person who's been harmed for damages or losses incurred by the defendant's action or lack thereof. And also this serves to discourage the defendant from repeating the same type of behavior in the future, hopefully. So the individual that files the lawsuit is called the plaintiff, and the person who allegedly caused the damage or the injury is called the defendant. And the way that tort law works basically is just as Automobile drivers have a duty to drive safely and follow the rules of the road so that we don't harm other drivers. Nurses similarly have a duty to deliver safe and effective care in the way that clients or our consumers of care are not harmed. So these are the legal duties that sometimes get violated either intentionally or unintentionally and may lead to a tort. So the type of quasi-intentional tort that we mentioned usually has to do with a wrongful act based on speech, a statement that someone has made or either written in a medical record in a way that it inflicts harm either economically or causes damage to a person's reputation. So basically everybody's heard of this. We call it slander and libel. Slander is in writing, libel is verbally. Negligence is a type of tort that has to do with usually failing to do something to provide adequate care such that a reasonable or prudent person would have done that has resulted in harm to the person. And specific standards have to be met in order for it to qualify as negligence. For instance, if you accidentally give Tylenol instead of ibuprofen to the patient, so it wasn't the correct order, but if the patient wasn't allergic to Tylenol, no harm was done. So that doesn't constitute negligence necessarily. However, if you give the wrong pain medicine to a client, maybe it sedates them, you don't put up the side rolls, and if the client falls out of bed and breaks a hip, then the conditions for negligence have been met, because we all know that patients with sedating medications who may have ambulatory problems should have the side rails up. So the law defines the standard of care that you have to meet in order not to be found negligent. As any reasonable, prudent nurse would do this with similar education, would do this so that this would not have happened to the patient. Malpractice is similar to negligence. However, this term is more often used when it refers to specific duties that would require specialized education, like a doctor or a nurse. Good Samaritan laws protect practitioners in usually an emergency situation. If you are on an airplane and someone is in the next seat is choking to death on airline food, if you attempt CPR, and basically if you broke a rib, then this person could not sue you because you acted in their best interest. That was not a client that you were assigned to care for by a hospital or a healthcare facility. You were just being a good Samaritan, and in most of the 50 states, they have a law to protect us in those situations. It was probably better that you did try to help this person out than what would happen if you did not. Lawsuits sometimes happen over breaches of confidentiality. This is why we're always told as nurses to be very careful. If you're with other nurses heading down to the cafeteria on your lunch break in the elevator and you're discussing a patient, you don't want to do this because it could be overheard by a family member or someone else who does not have a right to know any information about this patient. So you want to be very careful not to commit any breach around confidentiality with your client. HIPAA law, the Health Insurance Portability and Accountability Act of 1996, came about because people foresaw that electronic medical records were coming, and they knew that this would not be as safe and secure as a paper record. However, electronic medical records are important for billing and also to facilitate healthcare in several other ways. But we all know that when there was one copy of the patient's paper medical chart and it was in medical records and somebody knew where it was at all times, when it was signed out, we knew who had it, that there were some ways in which medical records were just more secure. And now we've kind of lost this with computer hacking and screens being left where people can see them, and also with passwords being not taken care of securely, and so on and so forth. So we do know that there are certain risks to privacy and the security of patient data And we certainly wouldn't want this to happen to anyone in our family or ourselves if we were the patient. Another issue with confidentiality and professional behavior has to do with social media and social networking. We all know that whatever we put out there is going to be seen by the public. Once it's out there on Facebook or Twitter, Snapchat, Instagram, it's very hard ever to get this information back because photographs can be downloaded, screenshots can be taken, and so it's very hard to ever take something back. So we all know that as professional nurses, we need to be very discreet about anything related to our personal lives that we do post on social media. You want to please just be aware that state boards of nursing have taken disciplinary action against nurses who disclose patient information on social media or did anything unprofessional on social media. I'm sure that none of us would ever do that, but we just have to be aware of this. Examples of this would be posting pictures from clinical, maybe taking a selfie with a patient innocently, anything around HIPAA or protected health information, maybe even saying some things about your employer or the hospital could cause problems. So please just be very, very careful and cautious about everything that you post on social media. So, we're back to slander and libel. I think I may have gotten the slides out of order. I'm so sorry. Anyhow, this goes back to the quasi-intentional torts, which are civil lawsuits. Slander has to do with defamatory statements or defamation of character. If you put anything negative about a patient, you want to be careful. There is protected information around patients who have diagnoses of substance abuse. You want to make sure that you don't say this erroneously about a client. You don't want to make any false statements about a client's condition. And then libel has to do with the spoken word. You never want to say anything defamatory or negative about a patient or their family or even your coworker. Think before you speak or write. Sometimes comments that appear to be harmless, like a complaint in the hallway, can be taken as your attempt to damage somebody else's credibility personally and professionally. So just be aware. We want to talk just a minute about the legal concept of false imprisonment. This is something we think that we would never do. This has to do with restraining or holding someone against their will, either verbally or physically, and detaining them. This could be the use of restraints on someone without following a proper protocol. This could be restraining a mentally challenged individual who doesn't necessarily represent any threat to themselves or to another person in the immediate vicinity. This could be detaining clients if they want to check out against medical advice and you advise them not to leave. This could be keeping people who are medically cleared for discharge an unreasonable period of time. The doctor has discharged them, but it's maybe taken 4 hours to, get the discharge plan together so they can go. This could be doing something like taking away a client's clothing so that they can't leave when they've expressed a desire to do so, and obviously they don't want to leave the grounds in a hospital gown. Or this could be even a threat with some form of like action or some kind of even threatening them with physical restraints if they desire to leave. We need to point out that sometimes clients are a danger to themselves or others. Maybe they're suicidal, maybe they're agitated, violent, psychotic. So nurses are called upon to assess the appropriateness of restraints and to do it within approved and established protocols. Restraint should be used as a last resort. It's very important to assess carefully, document thoroughly, follow protocols, carefully monitor this person while they're in restraints and document carefully. so that you don't fall victim to being charged with negligence or false imprisonment or anything of that nature. I want to talk for just a minute about the concepts of assault and battery and differentiate the difference. Assault is a threat to do harm, usually verbal. Battery is actually touching another person without his or her consent. So assault may be something like, if you don't stop pushing on that call bell, I'll sedate you. This would be considered an assaultive statement to that client, even if it's said in good humor. Battery would be sedating someone maybe for their own good. Clients do have the right to refuse medical treatment. We, in general, with few exceptions, can't force them on. Sometimes holding down even a fairly agitated or violent client against his will and injecting medication may be considered battery. Doing surgery without informed consent can also be considered battery, so just be aware. Let's talk for just a minute about standards of care or standards of practice. One of the defining characteristics of a profession, as we talked in Chapter 1, is our ability to set standards for members of our profession and for our behavior and our conduct. The state boards of nursing and also professional associations like the Florida Nurses Association develop standards and they delineate responsibilities. The state boards of nursing, sorry, had a cat jump in my lap. So the state boards of nursing also establish standards of practice for each state. In Florida, our Nurse Practice Act is Chapter 464 of the Florida statutes. These have been voted upon by the legislature of the state of Florida. So standards of care or standards of practice are also used to determine whether the appropriate care has been delivered if there's any kind of complaint from a patient or from their family. Some standards are written in the form of our job descriptions, maybe policies and procedures for the agency that we work for, and so on and so forth. Most of them are based on evidence-based practice, which is research-based, which is treatments that are appropriate and are found to be safe and effective through many years of research. Institutions also have their own internal standards of practice. What's acceptable to do at Shands UF Health may be a little bit different at North Florida Regional. Any or all of these standards that we just mentioned may be taken into account whenever there's an accusation of nursing malpractice or negligence, as well as expert witnesses from other parts of the country can be called in to testify about whether the standards of care were met or breached. Let's talk for a couple of minutes about the legal concept of informed consent. Informed consent is considered a legal document. It has to be in writing in all 50 states. So basically, the parts of it have to be the risk, benefits of the treatment, which is usually, often a surgical procedure, as well as any alternatives to the treatment. Maybe instead of a lumbar laminectomy for chronic low back pain, maybe the alternatives to treatment would be physical therapy and so on and so forth. And also the informed consent must list what's likely to happen to the patient without the treatment so that the client can be fully informed about what they're about to undergo. So according to the law, the person who is going to perform the procedure is the one who's legally responsible for obtaining the informed consent. If that's a surgical procedure, it's usually the surgeon. However, nurses are involved in obtaining informed consent. So here are some of the criteria if you're asked to get an informed consent form signed by a client who's going to go for surgery tomorrow morning, for instance. You want to make sure it's a mentally competent adult who's voluntarily giving the consent, that they're mentally competent to do so, and that they're not being coerced by a family member in some way. Make sure that the patient understands. This may involve an interpreter if English is not their first language. You want to make sure they understand the risks involved in the procedure. You want to make sure that you get this in writing, that the patient signs, and it's not just verbal. If it's a minor, somebody under 18, then they need a parent or guardian to sign. Two things that are most important are you want to really make sure the patient understands what's going to happen. Yes, they can say, yes, I understand my gallbladder is going to be removed. Yes, I understand my appendix is going to be removed. And you want to make sure that not only is the patient mentally competent, that they're not sedated. If you have to wake up this person after giving them a sleeping pill to sign an informed consent, then you may not actually be able to say that. And the client can refuse to sign an informed consent. They have the right to do so. And we are their advocate in that process. Implied consent can happen when it's assumed that the patient would want this. Usually this is in an emergency situation. If the patient has just been brought in 911 to the ED, they've been in a car wreck and they're not conscious, it's safe to assume that you would want that they would want you to treat them. If you can't get an informed consent, then that doesn't stop the process of treatment from happening. So one thing it's important to point out is it's a lot easier to prevent a lawsuit than to defend yourself against one after it's already happened. If nurses consistently demonstrate a caring attitude and interest toward their client and family, a positive and trusting relationship happens, and this goes a long way toward preventing litigation. People rarely sue someone they like. If they feel like you care about them and you're competent and you're acting in their best interest, this goes a long way toward preventing litigation. In malpractice suits against physician, the most common complaint from patients or their families is the doctor didn't listen. Just some quick tips about how to avoid legal problems in the clinical setting. Keep yourself abreast of the latest evidence-based practice and new research related to your clinical area. We do this usually through reading journals and continuing education courses. Always maintain a safe and, patient safety is a big thing. If there are patients who are at risk for problems, make sure you're on the lookout and you identify these and address them, such as a fall risk for decubitus ulcer, and so always document precisely and carefully. Don't ever leave at the end of your shift without finishing your charting. Always write an incident report when required, and you'll learn to recognize over time certain client behaviors that might indicate the possibility of a lawsuit. These are just a few brief tips about effective charting. As you know, if it's not documented, it's not done. So make sure you chart carefully. Make sure it's legible. There are a lot of spelling errors in electronic medical records. Thank God we don't have to read so much handwriting anymore. So in that way, things have gotten a lot better. Make sure you finish charting before you leave at the end of your shift. The rules still apply with the electronic health record. Make sure your typing is legible and avoid all shortcuts. These are some common mistakes that can lead to negligence or malpractice: failure to assess a client properly, failure to document in the patient record, failure to provide patient education to the client and their family, and any violation of either an internal, external, or other standard of practice. It's a very good idea to carry your own professional liability insurance. For registered nurses, it's not that expensive. You're always going to be covered under your hospital's umbrella policy, but it's not a bad idea to have your own as well. So please look into that. Let's talk for just a minute about DNR orders, do not resuscitate. So this means not to initiate CPR. If your client has a DNR order on the chart, please make sure that they and the family understand what this means and what is and isn't going to be done. This can also be a source of litigation. And to follow up the DNRs, let's talk for just a minute about advance directives. There are often legal dilemmas about this that court decisions have had to be made over. So federal law actually mandates that we inform patients of their right for an advance directive. They need to decide in advance what their final wishes are. The most two common documents are the living will and the durable power of attorney, which designates a healthcare surrogate who will make the healthcare decisions for that patient when they become incapacitated and can decide for themselves, basically. The living will documents whether they wish to have life-prolonging treatment in the event that they are no longer able to make the decisions and if they will not get better. One other important thing about advance directives is that the responsibility for making clients and their families aware of this often falls to nurses because we are their patient advocates. So nurses who are unsure of any existing policies and procedures about this should speak with their supervisor for clarification about living wills, DNRs, and other parts of an advance directive. So in conclusion, nurses need to adhere to all the standards of care and practice only within their scope of practice, and carefully document all client findings in order to stay safe and avoid legal difficulties. Thank you.